People will ask me, do I need a will or do I need a trust? Sort of what they're really asking, I think, put myself in the mind of the inquiry, how do I avoid probate? Really? You think that's what they mean? Yeah, I think they do. The traditional model is a last will and testament, and well, then you have to go to a lawyer, person like myself, and probate the will. And that's just because the court has determined, society has determined years ago, that if a person has an asset in their name when they pass away, you need to go through a court created and a court process. You need a petition. You need certain time frames involved. You need to know who the creditor is, identify assets, verify the will. That's a court process, and that court process takes place if you have an asset in your name when you pass away with a will. And if you don't have a will, that process still takes place, but then it's called an administration. So when someone asks, should I have a will or a trust, they probably mean a living will, a living revocable trust. That's what they mean, not a living will. They probably mean a revocable living trust. There are many flavors of trust, revocable and irrevocable, but the living revocable trust, revocable living trust, that's the one that avoids probate. And then you don't have to go through that court-mandated process, the process where the court verifies assets, requires a petition, requires affidavits, documents, notice periods, verification of debts, assets, and obligations. You don't need that with a trust. That's probably the information people are looking for. But if you'd like to know something else or want to ask a different question, reach out. frankbrunolaw.com.